everyone, and welcome to today's first sessions with Sarah. So in these segments, we're just going to do a couple of quick few minutes on different processes in the law and answer a couple of your questions if you have them. Today we're talking about how to get a divorce, but if you do have anything you'd like answered, feel free to leave a comment or send our page a message and we can deal with it next month. So we'll jump straight into it, how to get a divorce. So the first step is obviously pretty simplistically to separate from your partner, and you do need to agree on what date you've decided you've separated from your partner. And this date becomes important because you cannot apply for a divorce until 1 year after your date of separation. So let's say you separated today, you won't be able to apply for a divorce until the 25th of March 2022. I had to think about that, which is a bit sad. So once that 1 year has lapsed, or if it already has lapsed, you can start the process of actually getting involved. So firstly, you need to decide if it is a sole or a joint application. Now the difference between these two things is that if it's a sole application, that means you are applying on your own. If it's a joint application, you and your former partner are agreeing to sign the application together and submit it to the court. There's advantages and disadvantages to doing it both ways. For example, if there's a joint application and there's children under the age of 18, you won't actually need to do the court appearance. Whereas if it's a sole application and there's children under the age of 18, you do need to do a court appearance. Another benefit of doing a sole application potentially might be that you have a concession card and the other party does not. So by doing a sole application, you're entitled to a concession, which is about a $600 saving on the filing fee, as opposed to if you were to do it as a joint party. But obviously a sole application often can be the only way to do it because you may not be able to contact your ex-spouse. Once you've made that decision, you can actually fill in the application. It is an online form these days, however we can prepare it for you, or you can decide to do it yourself. It's through the electronic platform called Comcourts. Once it's filled in, you need to add in any other documents that support your application. So for example, this might be your marriage certificate, which is normally required. If you were married in a different jurisdiction, if that marriage certificate is in a different language, you'll be required to provide a translated copy of that document. You may need to put in proof of citizenship. So if you and your former spouse were born overseas, that is often required. And potentially you might even need to do an affidavit supporting your application. And this is mostly needed when, in those 12 months since separation, you and your former spouse have lived under the one roof. And essentially what the court wants to do is establish that you have in fact separated. If you're obviously living under one roof, then obviously it's a bit harder to meet that requirement that you have separated. So you do have to say things like you weren't living as a couple, you weren't perceived as a couple by your friends, you kept your finances separate, you both paid your bills separately and the like. So once the affidavit is done, if needed, or the document submitted, citizenship proof is in there, you can sign the documents. Now, once you've signed the documents and submitted the documents, you select a court date. Court dates are always required in all matters. However, whether you need to attend the court date depends on your circumstances. And at the moment, it's taking about 3 months to get a court date with the family court to have that divorce heard. So it can be quite a lengthy process. Once it's signed and submitted and you've got that court date, often the next step, if it's a sole application, is to formally arrange service on the other party. So service is essentially when you have a document and you give it to someone in a formal manner so the court can be satisfied that they have a copy of it, they know what's going on and they have no objections, or they have an opportunity to provide that objection. We normally pay people called process service to do this for us. So this is a person who will physically find your spouse wherever they are, knock on their door and say, "Are you Joe Bloggs?" "Yes, you are. Here's some documents for the Federal Circuit Court." Once that's all done, they sign an affidavit of service. It's not always necessary to have a process server involved. You can potentially serve yourself if your spouse is willing to sign acknowledgement of service, or they can attend our office to pick up the documents if you're still on speaking terms. So once that's all done, we file the affidavit of service, but however, in joint applications, affidavits of service are not needed because obviously both parties are still involved and are involved in the case already. So once that's all done, it's a bit of a waiting game. So like I said, you generally wait maybe about 3 months to get a court date. It does depend on how busy the court is and what their workload is like. For that court hearing, if it's a joint application, you do not need to attend. If it's a sole application, where there's children under the age of 18, you must attend court. It's held by a registrar. It's pretty informal and a lot of parties represent themselves with that because essentially what the registrar is trying to establish is that the children are cared for. If it's a sole application and you don't have children under the age of 18, or your children are flown the nest and fully grown up, then you won't need to attend court either. The registrar just makes the orders in chambers without the need of appearance from either party. So once the order is made, we get notified, but however, the order does not become available for 1 month and 1 day after the court hearing. So hypothetically, an order is made today, it'll become available on the 26th of April. So you have that 1 month and 1 day holding period. And then it's official. You can do whatever you need to do, use that document to support anything else that's needed. And so that's basically a summary of how the divorce process works. You can do this process yourself, however, a lot of parties find it a bit overwhelming and prefer to have legal representation. If you are going through a divorce, it's always good to have a discussion with a lawyer about the financial consequences and potentially children consequences of that divorce and what the time limits are and how it needs to work. So I would recommend, even if you consider doing a divorce process yourself, that you do get some legal advice to just make sure you know what you're doing and you're not sort of cutting yourself off from a potential property claim or, something along those lines. That's about all from me today. It's short and snappy, but like I said, if there's any requests for something, I'm happy to talk about family law, property law, or even other areas where we may know a bit about. Please submit them in the comments, or there will be a post going up, and I'll be back next month. Great, thank you very much.